Hello, loveys. How are we? It is March 20th, 2025. And tonight we are together to discuss mayhem, malarkey, and the stream full of steam coming at you from Norfolk Superior Court. What a day. What a day. Let's say hello, loveys. Hi. Hi, Andrea Clark. How are ya? Oh, Shirley says, do it. Shirley, I don't think I've felt things that I have felt today in quite some time. I was tingling. I was looking at Yannetti like a bowl of spaghetti. And it felt right. That's all I know. Oh, thank you, Julie. This is a hat from I don't even know where. I think it was like Fanletics or something a couple years ago. I got it on clearance. I believe it was $17.99. Oh, hi, Colleen. Love your face too. And yes, here it is. Dance Kinetic fan Miyabito says Yannetti has had enough of BS Bev. BS or bias, Miyabito? I think both. Pray tell. When I look at Hank Brennan, I feel many things. He reminds me of a villain in Harry Potter, just a slender version. And he also looks like he bleaches things in a basement. You know? I don't know what that says about me, but it's like he's bleaching the basement repeatedly. And his mother's like, "You missed a spot, Hank. Hank Francis, first of your name." I don't know. Yep, there it is. And May Cronin says, Bev's bias BS. We should do the triple Bs. We could maybe make it a quadruple B. I don't know. Yes, BL. Oh, sorry. I don't know where you are, but BL, you said, here it is, that his voice is nails on a chalkboard. And Squirrel, Secret Squirrel, I love you so much. I can't find you, babe. You left me, or I have left myself. So we have felt all the emotions. Earlier tonight, guys, I found myself on Valhalla's stream because his goats had babies. And I don't know why that, I was just entranced by them. There was a baby goat named Dottie, and she's just jumping around town. And it's literally bringing me joy. It's curing me of my seasonal affective disorder, and it was happening in real time. Every jump of baby goat Dottie was, I don't know, it put years back on my life, maybe, because we're not doing goat yoga as a community quite yet. We at least have Valhalla's stream to watch the baby goats. All right. So, Darlene Wolf loves those baby goats. Are you kidding me? I have never seen them before. That was my first time, Darlene, and I'm so thrilled that I got to go. I hope he does it again. Okay, yes, and May Cronin also knows that the baby goats are the best, as does Mary Romine. The goats got ya. Okay. Oh, look at P. Look at you saying tap that like. Oh, stop it. You're a sweet P. That's what you are. Okay. So, babes, today started off in a way that I have to tell you that last night I was unwell, okay? I had gone through all the highs and lows. I said to myself, this is incredible. We got Trooper Proctor. Bye-bye. Dishonorably terminated. I didn't know that yesterday morning when I did our stream, when we were just streaming around town together. We had no idea that it was going to be quite a wild Wednesday. But then it turned into a thirsty Thursday, and all on Hank. Okay, he's thirsty. He's real thirsty, parched, if you will. Get a drink, Hank. Don't get dehydrated. So we find out from Turtle Boy last night in a like cryptic weird tweet that he's like, I will be sitting at a defense table with Karen Reed tomorrow morning. And what do? Have GI upset. I am immediately unwell. I am like, wait. We had such a good day. Why is this happening now? And but I know that, like, if he's tweeting it, then, like, clearly, you know, it wasn't the end of the world, but I went through the 5 stages of grief. I prayed literally the rosary, and I was like, Please, please, God, tell us what to do." I just kept saying it to myself. I was like, "We're gonna get through this. We're all gonna get through it." And when Hank got up to do his little speech this morning, his little overreach speech, if you will, Rule 17 edition, he mentioned things that he didn't expect the judge to give him pushback, because he receives what? No pushback when he is in Judge Beverly Cannoni's courtroom. So this was a much different tone, a much different tenor, and a completely different judge. So it started off with a bang, and I didn't see Karen there. And then we will watch the beginning. We'll talk all the shit, go through the Cliff Notes version of today, because you've heard it from everyone else. You just don't need to hear it from me. And then we'll talk about all of our feelings about Proctor and the ID documentary, if you guys saw it, because I have thoughts, I have feelings, and I know you do too. So we're here for each other. That's what we do, babes. Okay? So let's get into it. Spanker, Hank Francis. How do I make myself little? I believe it's here. There she is. Okay. Lil Kim, the Queen Bee. Let's play it. Clutch your pearls and clutch your butts, babes.
And Ms. Reed's case, I have only sought information that's been publicly available, and that's why my motion cites a search.
It's not good. Oh, where did I go?
Search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public
Am I
docket.
here?
And so what I learned is from my public reading and from watching hearings. And so what I know is that there are 2 phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney.
Oh.
Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party.
Babes, I heard you say he's kind of low, and I don't know how to make that different. He is gonna be kind of low, and the stream gets whacked today, okay? So, like, you hear it loud, and then it gets wicked quiet. So I'm sorry. Do I know how to make this better? Okay. Let me see if I can. What is ambient? Does that have anything to do with it? No. I don't think that is the. Oh, look at this. What's this? It's a button. I can't even make the button do anything. What is stable volume? I don't know. It won't even let me press it. Okay. I'm going to just press that real quick and hope for the best. Okay. Back.
Would then be sent.
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well named. It may be. I don't know that.
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substance itself or in the addenda?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, conscience of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Carney.
Okay. So now he's just talking about like targeting of witnesses in Miss Reed's case. He didn't know the intermediary's name. Who is the intermediary, guys? That is Natalie the German.
Purpose, according to Mr. Carney, that this trial,
Oh.
Ms. Reed, never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
Oh, now, first of all, when I watched this earlier this morning, guys, I didn't realize that like Judge, oh gosh, I can't say his name, Sititska, is he kind of a salt and pepper shaker? Are we into this? Is he looking good in that black robe? I like a salt and pepper man with a full head of hair. What are we doing?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought.
Okay, Lauren TZY. Sisitsky daddy.
A broad swath of data. We don't know the volume yet, but it is from the addendum A, the search warrant, for calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, text, videos.
No.
Absolutely nothing to do with communications between the Mr. Kearney
This broke the internet. This broke my brain, broke the World Wide Web. Okay. Look at Mr. Yannetti. Oh, that's a thug. I don't care if you're wearing an appropriately length tie. Okay. You're wearing a red tie today, sir, just flapping right above your belt loops. Oh, who am I right now? Stop it. And then Karen coming in hot. Liza.
How can the Commonwealth make the threshold showing that it's irrelevant?
Oh my gosh. And Hank acts like a 4-year-old, you know, not getting his way, and his little sister has stolen his ball. Mom, Daddy, do you see this? Daddy, do you see what they're doing to me?
This is a ruling with Mr. Carney, so I'm asking that Mr. Carney has a start to be at the table. I'm not sure why we're being joined by.
Stop it. Look at Karen, guys. Look at Kat. Looking right through him, with him, in him, not in the unity of the Holy Spirit. What happened? What she is looking, she is saying, what did you just say? Who are you? I don't appreciate it. Shut your face.
As we say, have standing in this.
And the squint. It was the squint for me. And it was the shake your head and shut the fuck up, Hank. All the way up to what? Shut the fuck up mountain.
We're a little confused, and I don't mean to interrupt the proceeding, but as we're
Counsel, can you state
Now you
your
do.
name, please?
of course, I'm sorry, Alan Jackson on behalf of the prosecutor. We didn't see which case number was called for Rule 17, if it was Mr. Carney's case number or if it was Ms. Reed's case number. We were told or at least our impression in talking to Judge Canoni, was if this issue was going to be on our case number. I specifically asked that question at Sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the
This
issue
meeting is being
Counsel.
recorded.
Oh,
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Carney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here and she has a right to counsel, and we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because
wow.
it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
Now, here's where it got shady, babes, right? So it wasn't just Turtle Boy or Aiden Carney's docket. It was also Karen's docket. And it seems to me that it was like not portrayed appropriately to the defense, to Karen's defense. Bradel was 100% aware. I'm sure that Mr. Betterow was aware, but like the defense for Karen was not aware of this. And when they had gone, I think, to the sidebar on Tuesday, at the end of the day, I think that there was acknowledgement that there might be something coming down the pike for Turtle Boy, but I don't think Karen was aware her specific case number was also involved.
Which can be dealt with at a later time. Those are
Oh.
what you're suggesting are evidentiary issues, which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time. This is
respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over again, Your Honor. The Commonwealth has taken positions on Rule 17. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Canoni
Oh.
day before yesterday.
Oh, so no, they did know if they gave it to Justice
And what do you
Canoni.
propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Mr. Little is prepared to address the court on the very issues Mr. Brennan brings up.
I'll take it under consideration.
So he came out like a lion, guys, right? And we were thinking that Judge Satitsky we didn't know if he was going to be picking up what everyone was putting down. I'm going to tell you right now that Tim Bradel did a beautiful job. His argument, eloquent. He also was charming. There was a connection. They giggled twice, okay? It was a bromance born today. And Liza Little got up, she said her piece, and we got a ruling in this today at the end of the day from Judge Satitsky. And he said, I quote, this was big doings, babes. I didn't put it on my thing because why? I'm abnormal. But the finding was as follows. And the conclusion, milestone-ish. It says that accordingly, this motion is allowed in part, such that the court orders the Norfolk District Attorney's Office, Special Assistant District Attorney Robert Cosgrove, to produce from the 2 previously identified cell phones that were obtained through the search warrants in connection with 2 criminal cases currently proceeding against Mr. Aiden Carney, Commonwealth versus Aiden Timothy Carney. And it says, any and all evidence of communications between the defendant and Mr. Carney concerning 1, the communication between Mr. Carney and the witness or family members of a witness involved in the murder of John O'Keefe. Oh, I'm sorry. Uh, I'm sorry, Mr. Sistitsky, and my judge of honor, my sweet angel, my salt and pepper king. Did you just say any witness or family members of a witness involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, or Nagel, who knows, but he said Albert, Michael Proctor, and Elizabeth Proctor from April 8th of 2023 to October 5th of 2023. So ordered. Okay. Uh, shall we all be healed together? This is wild. I was impressed. What did you think? Yes. Yes, Maddie Wags. Can I show it to you? I can't even show it to you. Oh, I'm going to have to download it at some point. I'll put it up on I'll make a TikTok. Oh, yes. Yes, Mary B. Judge Daddy. Oh, hi, Ask Bob. How are you? Yeah. I'm gonna say it right. Sistitsky. Nope, not gonna say it right. Sistitsky. Okay. Yes. Oh, and Calico 26 says it should have been denied in total, right? It should have been fully denied. I totally agree, but listen to me, babes. It was only allowed in part. So we take the partial wins, right? And we shove them directly up the poop chute of one pencil loving Hank Brennan. Now, the next part that specifically rocked my actual socks off today was when we get into, oh no, I have to do this. Sorry guys, one more thing before we go, because this was the most incredible thing. And I wanted to thank Joe Flipahead on the frickin' Twitter, on the X, for making some of the second best memes I've ever seen, because Larry Legend is my guy. Go flip ahead. It's my guy. He's incredible. He makes the magic happen. And nothing tells us like it's going to be a good night than Rough Riders and DMX. Okay. So now we got through that and we were like, wow, I'm already heart racing. I'm at the freaking actual RMV trying to finish a registration situation because someone didn't mail me a decal. I got something in my pocket for you. It's right there. Okay. Um, and now we're gonna get into 137. Come on, Kimba. Cliff's Notes with Kimmy. Hello? Play
It
it.
has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's
Okay. So, babes, just because we know all the background, right? Do you know? And I'm sure that it was said on X, but again, where was I? Stuck at the RMV. Here is the problem. Hank Brennan gets up and he's talking all the shit about the jurors, right? Saying like, oh, the journalists, including TB, who is sitting right there, he's saying, can't be giving like descriptors of the jurors during the trial. Who was our homegirl who gave us all the descriptors on X? Jess Machado. Okay. She told me everything. I would do like I would know what juror number 4 looked like in my brain based off of her descriptions because she's incredible at her writing. And like he's giving this pushback and saying that no one should be able to do that. Well, bitch, she's not saying the actual juror's name just because you say, "Oh, well somebody looks like, I don't know, let's say maybe Glenn Close, right? Oh, it looks like the actress Glenn Close, or it looks like, Mrs. Roper from Three's Company." You're never going to know what they look like. She's just giving you the vibe in a character format. Fuck off for trying to take it away from us, Hank.
The last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There's been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Yeah, shut
Any
up.
objection from the defense?
Oh, look at my guy. Here he
Your
is.
Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I
Oh.
address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors.
Oh, well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Yeah, well,
Right,
thanks,
so
Ma.
we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to
Oh, hi, Will. And you dude did rock this shit. Everyone was incredible today.
FTR.
Okay, well,
on
that's what I'd
things
like
that-
to
All right,
address.
so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is
Yeah,
a
they
This is
change.
his
did.
trial, Judge.
Right. No, so
So,
just to be clear, this is a change.
I
Babe, are you kidding me? Did you just say to the teacher to her face? Yeah, this is a new trial. Did you use her lesson as an argument to stand up to her? I'm obsessed with him. And they did agree to it. And I think that the defense, in my opinion, was too kind, okay? Last trial. And they were kind of conceding in places that they maybe were like, I'm not going to put up the fight for this. Listen to Mr. Yannetti's argument on this, babes, because this is big doings. There should be specific things that are protective orders or juror related that should never come to the public, to us. But we have a right to know a lot of what has gone on at Sidebar, and especially because Judge Cannoni today made a unilateral decision, just like last trial, that she will not allow a speaking objection. So now Hank Brennan is going to be able to say objection with no hearsay, relevance, lack of foundation, no reasoning. He is just going to be able to say objection, and she will be able to determine in her mind what it is he was trying to say, and then they're going to finish up the argument if there's a question at Sidebar. It's bullshit.
don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court.
Yes.
Consonant with these policies, in one of your recent rulings, Your Honor,
Ooh.
the court recently cited to the strong presumption of Massachusetts law that a court will be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded.
Yeah.
If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the
Oh, I'm sorry. Is Mr. Yannetti acknowledging content creators? that there are people that write and speak about this case every day on the internet. Was that a shout out to your non-consensual intern, Mr. Yannetti? No, it wasn't, but still. Thank you for bringing it up. And thank you for also saying that we have the First Amendment right to know, to say what we want, to comment on it. And then we also have the right to that public information that you are making private in Sidebar and then impounding it as a blanket overarching, theme for the 2.0. It's not going to fly. And Mr. Yannetti is calling it out.
Internet sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
Now, take a moment to watch that body language, babe. Okay. So you see Judge Cannoni lean back. She fat Joed him. Okay. No one knew that was coming, but she did it. And she leaned back and she was like, tell me, Mr. Brennan. All right. I'm putting you on the spot here, Hanky. Let me know what is the precedent that I can legally impound these. And listen to this fucking klutz. Think about your life, Hank.
I don't have an answer to that.
Oh.
It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent.
Babe, but earlier in this stream, I said that I believe that maybe Hank Brennan bleached things in the basement. Now I know what those things are. His underwear, because he has shit stains, in my opinion.
Juror in a trial this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it. In fact, it resides in heavy promotion, the cottage industry in ways, unfortunately. And that creates an enormous amount of.
Now, I'm watching the frickin', because I can't hear him either, babes. I'm looking sorry that this sucks. But did he just say there was a fucking cottage industry? A cottage industry. I don't know what that means, but I feel like you may be hanging out with the yellow cottage. Too much, Hank. That's weird.
Of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government.
Yeah, there's scrutiny.
I agree the government should have a legal basis. If you give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right. So I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
I'll give you till tomorrow afternoon because you don't know shit about shit. Okay, per usual, Hank, you haven't done your fucking summer reading. You didn't do your fall homework. And let's be perfectly clear, you're flunking, okay? Everyone knows that a C student still passes, but you're looking real funky. Funky with an F, Hank. Ugh.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk.
Okay. And then where is my Liza? I want her to talk about, here it is, babes. This was a Nurse Kim rebuttal. Got me a little bit excited.
In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined.
Yes.
The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court manner of death, also not calling the medical examiner in this case, which creates certain issues. All of this is cited deal with because the Constitution. That
Oh, babes, I'm sorry. Did you hear that? Because it looked like it was lost.
I'd urge the court to carefully read that opinion because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have no doubt that a homicide, and the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you
Okay, babes, I don't know what is happening with my computer right now, but if you can hear me, can you say, I can hear you, Kim? I can see you, I can hear you. Because it's making me verklempt. I'm going to clutch my own pearls again over my own visual aids. Lord help us. Okay, well, listen, I am going to talk, and if you can't hear me, we're going to wish for the best. But Liza Little got up here and had a precision-like argument. Incredible, okay? A+. If I was grading her, she is valedictorian. Okay, she wears a cape on Tuesdays. But she got up and said that the only precedent that was like gleaned from the Commonwealth requesting this information to be suppressed was that there was a prejudice or of liability that could be sustained if somebody had unalived themselves, homicide, suicide, and what's the other one? Accident, right? Those are liable. You are liable for those three manners of death. Natural and undetermined, there is no case law for it. So what does this say? Then Liza takes it a step further. There was a hearing last week that Hank Brennan said, hey, bitch, it depends if we call Scorty Bello. Said some wild shit like we're not calling the medical examiner. Oh. And isn't that interesting? Because the medical examiner who was reached out to for 2 different meetings by former trooper, now disgraced, dishonorably discharged trooper, Michael Proctor. 2 times he had meetings with Scorty Bello, and she would not sign off, and she would not bend for him in order to change that designation and that manner of death. Huge. It is huge, guys. That is exculpatory. This is the same Michael Proctor who said on the motherfucking stand that in the 12 years of his experience at Mass State Police, he had never been involved in any sort of testimony or prosecution and, being a witness and investigating, pressing charges of a homicide and second-degree murder if there was not that determination. A homicide means death at the hands of another. And that was not determined in this case. Go to bed. Put yourself to sleep.
You say the medical examiner is not testifying?
I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scorty Bello.
Not on their witness list.
Right.
And our little asshole team captain, okay, Barney adjacent, Ms. McLaughlin, Law McLaw, she hits us with she's 81 on the witness list. Well, we didn't have fucking 81 as of Tuesday.
She's number 81 on the Commonwealth's witness list.
Of course she is.
I'll take this under advisement. I'll take a quick look at Ellis again.
Oh, thanks for taking a quick look.
I would just note, I apologize. I don't, Attorney.
All right. And she's not going to give that, but it doesn't matter. As long as Squirty Bello gets up there, we can cross-examine her and ask that, and she would be able to provide. So now we're going to Mr. Alessi and his incredible argument. Per usual, he is the master. He is the eloquent leader who we have come to know and love. He is our teacher, okay? He walks us through the law like he's Bettero on a show, okay? We're like, babes, are we watching the Young Jerks right now? What the fuck is happening? Because you've just taught me more things, and he knows all the things about all of the things. Like when he was talking about different geologists today, I was like, I didn't even know there was different ground, studies of geology. And he was like, oh, they're not a hydro. He's incredible.
We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability.
Obsessed.
And I've used the Latin phrase ipsi dixit, translated into because it says so, he said.
Babes, I am immediately going to say to my teenage daughters from now on, I'm going to be like, ipsy dixit, because I said so,
That's
bitch.
the ipsi dixit comes right and is used in case of cannabis. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it.
He's coming for Judson B. Welcher, who is he's a biomechanical engineer. He, I think, was found on the World Wide Web. Okay. I think that somebody in the anti-Karen Reed movement brought him up, and he sent an email to someone, and then all of a sudden now he's an expert for them. But his report is wild, babes. You're going to hear Mr. Alessi tell us that he is using lay people, not lay people as in like, are we fucking? He is talking about lay people as in witnesses and people who are living at the, or not living. Well, yeah, they were living at the house too. Brian Albert, Nicole Albert, Julie Nagel, all of these witnesses that allegedly didn't see Officer John O'Keefe. And he's putting it in his report as an expert. Oh.
The reason I perseverate on this is because that's exactly
When he said perseverate, I perseverated. Okay. I've perseverated ever since he said perseverate. He's a man. He speaks my language. I'm obsessed.
what Dr. Welcher is doing in a 140 slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology.
Yeah.
Just like Dr. LaCava in case of Caravan, he doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Albert Lanigan analysis is referred to as the hard science. So he also, Dr. Welcher, conducted an experiment, and I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused, and caused is italics in the opinion, her to suffer from MCS. This was an error. They went on, quote, because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct Flanagan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion.
Bitch. Okay, so we wanted to go there, and then I just wanted to get us to, where is it? 4258, because he goes on because he has so much to cover and
Extraordinary.
fight. Oh, here it is.
Moments I'm sure your honor may wish to not remember, but with regard to Mr. Green, et cetera, we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations, 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition.
Oh.
D, air temperature and frozen ground.
You know what he's saying right here, babes? This is what it felt like to me. It felt like to me, he said that, you know, it's always the rules for thee, but not for ye, right? And that what you have done to the defense's witnesses is shameful, to be honest, right? These were witnesses that already were allowed to testify as experts in the first trial. We know that they are different trials, per Beverly, but what is expected and the threshold to meet this criteria is widening and expansive from what is the criteria that the defense needs to meet versus what the prosecution needs to. And I mean, this is plain as day. If any asshole on the World Wide Web tells you that, like, oh no, where Judge Canoni is just calling balls and strikes like a champ, she's not a good okay? She would have been 100% fired from her position at least, I don't know, 2 years ago.
I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it.
This was it.
Of D. Then E. I'm sorry, Mr. Brennan.
It's rough. The frozen ground, we're not going to bring in the air temperature report because it talks about density of the strength of the detail. That's part of the conclusion. So there'll be evidence before he testifies.
We can't hear anything. Saying that he's not going to testify to that,
There is
to the
zero
frozen ground.
support for this experiment. I went through in Rentola.
Oh, yep. Then he goes over an experiment which applied the answers. He would have
credibility of
nothing
the witness
nothing
could
of credibility
substantially
if he
influence the
didn't
jury's
do
decision
this
about whom
experiment.
to believe.
But like,
And
where the fuck
lastly,
did you do this
importantly,
experiment?
Should the Commonwealth try to save this wayward part of the report by saying, well, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear, as I have.
Yep. He's incredible.
Will, of course, await the narrowing as your honor has.
Oh, we got to get to the 144 slide. Sorry, bear with me. Here it is.
It frankly shouldn't be the job of the defendant or the court
Ooh.
to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation.
Sure do.
That is unintelligible on its own. You can't understand it in the
When I tell you after this argument, guys, I was ready to go hit a vape. Okay. I didn't know if I needed to like have caffeine, if I needed to go watch like The Notebook. I fell in love.
Report merely references it, it doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted, but there are different demonstrations.
Yeah, cool dick breath. No offense, Hank, but you got dick breath. And this is why you are standing up and saying, "Hi, yeah, we did provide 144 slides that were probably made like a ninth grader who 100% plagiarized, okay? No one used MLS format and you know that, okay? Anyway, or MLA. I don't even remember what it was. I'm elderly. Okay. So then he gets up and says, "Well, we have to redact things." Cool story, pal. It's 11 days away from the start of trial. Today is March 20th. We know that Judge Canoni said, I want to be knee deep in clams, and there's no way I'm pushing this back. It doesn't matter that the defense filed the stay. She is going to push forward because it's fucking up her summer. And Bev's summer matters. She needs weekends. She needs summers. Okay.
That we do expect. The demonstration at Meadows Road, which clearly fits that the cars didn't contact the taillight, we want to produce. The drop test, similar to Arca's test, we intend to offer that. But as far as the extraneous,
Oh, I can't even hear him. I hate him. I hate to hear him.
Your Honor, we have an issue. Still, can we submit something to the court? Don't need it in the court hearing, but if Your Honor would like it, we're happy to give the.
Sure. So you'll get what you're entitled to, and which is
Correct.
just a narrowing down of what you already have. And then if you need to respond, you can respond. We'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher
Here it is.
is, in my experience,
Unprecedented.
unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said, they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher,
Yes.
cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court as the gatekeeper.
Yes. We have to have the gatekeeper. And now Hank gets up.
from Dr. Welcher, we gave any reference material
Oh,
until the day before trial to get simple Rule 14 discovery. Arca and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any.
he gave 8 giggity bytes. Okay. He didn't even know what the difference was between a gigabyte and a megabyte, right? He screwed that up in front of the court. I don't know how, or gig and gigabyte. Yeah, he didn't know that. Also, he said hashtag instead of hash value. And listen, I can't say anything. So oration for me, a little bit difficult. I call people the wrong names all the time. But when you want to talk all that shit, you wonder why you have dick breath. You know what I'm saying?
Reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what Arca even considered in this case.
Oh, far beyond. So Judson B. Welcher, a fan, okay, a stan, if you will, a Commonwealth stan. We need to start playing. I need flip ahead, and I need I Larry Legend immediately. Leah, where are you? I want a picture of Judson B. Welcher with and Devin Sawa in the Stan video from Eminem's 2002 hit Stan. Okay, because this is what it's giving. You like reached out, you were like, hey, I could help you with that. And then you weren't like, let me stay in my own lane and do biomechanical shit. I would also like to comment on exactly what happened. And if I could be present, may I also help Buchnick like harass people for rubber duckies in the summer at some point? He wants to hang out with the Commonwealth. He's a hang around. He's a groupie.
And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So for example, as Attorney Alisi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no.
But here's the thing, Hank, quick question. Why the fuck didn't you know that in his report? And why are you submitting things or allowing him? Did you not review it? Oh, Hank, do tell. Have you just not done any of your homework? So you're not helping your witnesses either, or your experts in this case. Okay, he shouldn't be writing reports to shit he doesn't know.
No damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or anything that relates to it. Similarly, 2-1 regarding Julie McCabe and grand jury.
Okay, he goes into that. We don't even care. Thank you, dude.
To consider these things in his study.
Okay, now this was interesting. This was one interesting point. Well, he made a couple today, but listen to this.
Materials he presented, that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data.
What the Christ are you talking about? How do you know? How does a biomechanical engineer visualize something? This isn't from an experiment, guys. This is him looking at what the ring video that Karen's defense team produced as exculpatory to her because she connected and you know had when she's getting out of the garage at One Meadow and leaving at 5 o'clock in the morning, and she makes contact with the traverse. Now he's saying that Judson Welcher also, guys, okay, listen, come close. He's going to tell you that snow moved off the bumper. Fuck you, Hank. Ugh.
Data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses.
Sometimes when he pauses, I think to myself, he doesn't even buy his own bullshit. You know what I mean? But then I think he does.
The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight.
The
and
height.
it shows with great continuity the height, location of that broken taillight,
Right.
and how it relates to a bent arm.
Cool.
And that is based on
Okay, so now, babes, we're gonna do a little experiment because we're gonna Judson B. Welcher this bitch, okay? And let's make our own theory. I actually heard the right arm being in this pattern, right? Like being put up, adducted, if you will, and put up, bent, since Kevin Linehan in the cottage, okay? Mom and pop business, Kevin Linehan. And he was like, that makes sense. That makes sense. If you look at all of the abrasions, that all makes sense. Okay. But if that's what struck Officer John O'Keefe and his arm was like this, and it lines up very continuity, like it's so, there's so much continuity and he is so correct and it's just incredible, okay? Where was a glass? Okay? Because there was allegedly, was he holding the glass? Was he not holding a glass? Did the glass break on the taillight? Did his arm break the taillight? What the fuck broke the taillight? Because polycarbonate plastic is used in jets, it's used in airplanes, it's used for pressure, it is used for the amount of pounds per pressure, pounds of pressure it can withstand. It is a really highly durable material. And now we have a man's arm potentially holding a glass that tiny pieces of glass did not match the glass that was found around his body. So now, okay, he is holding his arm like this. He's bending it up, okay? He is struck by the taillight at 24.2 miles per hour. He is pirouetted, lands on the ground. And at some point, because his arm hit it, then the glass was also shattered. And those shards landed directly around the final resting place of Officer John O'Keefe. Oh. Well, Hank Brennan, I want you to fucking play the Powerball, you dumb fuck. Because this is improbable to the nanomillionth, gazillionth. I don't even know. To infinity and fucking beyond. Call me Buzz Lightyear. What are we talking about? You guys keep moving the goalpost and it's a little uncomfy. Because that's not what your expert said last trial. That's not what Trooper Paul says. Okay, Trooper Paul doesn't even know what Trooper Paul says, but you know what I'm saying. This is wild. And I know, please, we know, listen, who are we dealing with? We 100% know that the defense will cross him and we'll figure it out. But you coming up with new theories of the death of Officer John O'Keefe feels very prejudicial to Karen. It feels like it's giving, you don't know what the fuck you're doing.
Engineering, biomechanics, the same things that Archer employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that Archer proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to.
I just want him to
present
say about the phone.
Demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be
Naked opinions, okay? Naked and cottage. Don't put those two words together. You'll have nightmares tonight.
trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the Archer information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses.
Babes, this is mind-blowing to me because, again, this is a material misrepresentation to the court. The defense has already provided all of the information that Hank Brennan got up and with his brazen fucking balls and said that he received it from who? The U.S. Attorney's Office and the feds, right? He's like, oh, I got this. I sent a TUI request in. Or you got an email from Liza. Okay, so they've already gotten their reciprocal discovery. They provided the bill that they received that was like a little bit of a whoop, a little bit of a clutch a butthole moment, right? And they paid the $20,000 bill, which was not any part of their opinion and or report, but I digress. They've given them all this information. It's already been handed over to the Commonwealth well within the Rule 14 timeframe. And yet he still gets up and talks all that shit. He just can't stop. Hashtag can't stop, won't stop, Hank Brennan.
So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery. Okay. Sure.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say.
Yes, it
moments
is.
ago.
Tell him.
He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the app.
It's science and data, which feels wicked reminiscent to it just did. The crime scene told me. We've had a couple of these moments in this trial, but if an expert wrote that in the report, which I know they did because why? It's quoted by Mr. Alessi. That is wild. And I fear, babes, that this 141, whatever PowerPoint presentation, it's clip art. He has clip art in it. Oh, Judson.
Dalbert Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1,
Let him
2,
cook.
and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it on a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what
Clutch 'em, babes.
Dr. Welcher did with regard to medicine and medical issues. That is completely false.
Yes.
ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force.
Babes, he's Doc, right? He's Doc, and he's getting us to 88 kilowatts right now. Are you shitting me? Tell me more.
And the calculation. What is known, M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfied.
He's incredible. He's incredible. And I just want to get to this
by
disingenuous
the media. They want to
return.
create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a
Babes, I would like to ask you, just based on what you have seen, and I know that we do have a tendency to lean to our teacher, our guider, our sensei, if you will, Robert Alessi. But he could tell me anything, and I bet he knows more than 99% of the population. He is a sponge. He takes so many things in and is a gift. He is a gift. And for Hank Brennan to get up and say he was wrong, I don't give a shit. Okay? I don't give one shit. I think that you are a liar. I think that your pants should have caught on fire. You'd be a dozen 5 alarms by now, pal. Okay? You are a fresh pants. Okay? That is your second suit that you've worn. And you're rude. Don't talk shit to Mr. Alessi. He's fed up with your bullshit. He has taken enough. He hit the button today. And you don't want to see him when he gets angry, Hank. Because he's going to win every single time. Babe, put a 1s in the chat if you trust Mr. Alessi on anything that has been reported from the podium. And put a 2 in the chat if you trust anything that was said by Hank Brennan.
dispute. But when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alisi is joining the fray, and that is all part of the strategy here. Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review, there are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right. Thank you. So we're going to move on to try and get some motions in quickly.
Now, the only other thing I wanted to say about that entire expert exchange, right, babe? So Hank Brennan got up and he said that it was appropriate for Welcher to have his opinion on the biomechanical stuff. Anything that ARCA commented on, they should be able to as well. Totally agree. All right. If it's good for the goose, it's good for the gander because we play fair. But where he lost me was Hank says, I also think they should be able to agree with other experts or agree with other witnesses or whatever came in the testimony, which is bullshit. Could you imagine if the defense had ARCA on the stand and said, and ARCA says, oh, well, the FBI thinks Karen's innocent. I don't know. The FBI asked us to do it because, they came to a conclusion that she didn't do it. And if that's how we're going to play it, then fucking giddy up, game on. You want to use every asshole, the 12 idiots, okay? Not the 12 apostles, but the 12 idiots at 34 Fairview? Go for it. Go for it. All we need is ARCA to get up on that stand and to say the federal government hired us, the DOJ, and we don't think that Karen Reed is guilty. Her vehicle did not hit Officer John O'Keefe, and Officer John O'Keefe did not hit that vehicle. Then Karen and I are jumping on a plane. Okay, where we going? St. Thomas. I don't know, in my brain. I need a minute. Okay. We're going to just do a little siesta. It's a girls' trip. All the ladies. Let's go to a U.S. Virgin Island.
The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
No objection.
Okay, thank you. 583.
All right, now I'm going to through. Ooh, this is a spicy. We've got a spicy AJ on the loose.
Target range. Without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points.
Correct.
That need to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a what was considered and what was testified to in the first trial is a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty.
Oh, I'm sorry, babes. Loveys, I needed to have lovey-dovey in tonight. I couldn't help myself. And you remember, those were some of our best friends from out of town, the Kolakithises. They were like, Mrs. Kolakithis was like, oh my gosh, why don't you talk to me like that anymore, babe? And then hit him more.
Theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems that
Now, babes, do you remember when I told you when I was in court, right? When I would see Hank walk back to the podium and he makes faces? Well, listen, babe, if you see these little leggies right here, you see this? I know that. I know that fucking pencil skirt anywhere. That's the original petty paralegal. All right? That's an ill-fitting pencil skirt. And that's Hank's paralegal. She sits right there, and what does she do? Vigorously writes on a legal pad. She has box-dyed blonde hair. I said it. I said what I said.
the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes.
Okay, everybody, class, hi, loves, okay? Just wanted to let you know, babes, yeah, she was pissed at John that night. Want to know why, Hank? Don't worry, I did your homework, all right? I can be your tutor. Just pay attention to Nurse Kim. Here's what happened. She went out with her boyfriend. Okay. She goes, they have a good time over at the CF McCarthy's. They head over to the waterfall. She is waiting for him in the car and he doesn't come back out. She says, fuck this shit. I'm going home. Now, when he doesn't answer the phone for her and she's like, this is rude. Okay. This is rude. You're using me, John, because I am where? Back at the house with your niece, and you're out playing hide the salam somewhere in a neighborhood between 1 and 4 hoes that you used to bang. Okay? We don't know who, but you could have played like, musical vaginas. I don't know what you were doing. But of course you go to that place when somebody who you are supposed to be with does not answer the phone. I'm going to say some wild shit. And I have said this since I saw this case on the news. When I first saw it in in February of 2022, when Karen was initially arraigned, I thought, oh, terrible accident. Oh my gosh. I'm so sorry, Officer John O'Keefe. That's terrible. Then when they increased her charges and we found out that it was like based on these voicemails, that she showed what? I don't know, very, very normal, a little bit, just a little bit. I'm pissed off. She didn't say, hey, I'm going to fuck you up. Hey, was that you? Did I whack you? That's terrifying. She's literally saying, you're using me. I'm out of here. Go fuck yourself. You're a pervert. That doesn't sound at all, although it sounds angry. We need 12 women nurses on this jury. And then we're going where? St. Thomas.
She was asked by Ms. Voss on June 20th, 2023 about that night or the day before. And she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep.
And Hank, here's another thing. You don't clearly know when she fell asleep, right? That was after 1:30 and she was up at 4:30. So no worries. We continue to do the homework for you, you damn pissant.
Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. This is minutes before we alleged the collision happened. And so in the interviews that she has provided.
Here's the thing, is that most men have what we call hoes in different area codes, right? Okay. It appears, I don't know if this is accurate, but maybe Officer John O'Keefe had hoes in one area code, and that is a fatal flaw. Okay, that is a fatal flaw for any man. So try to get that under wraps. Any boys in the chat? My 5 men that watch my stream, please, if you're going to cheat in a different area code. Cheat as far away as possible. Don't make your lady friend look stupid.
To these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have statements from the defendant herself that show.
And see, here was the thing, is though that's a misrepresentation too, because who was talking to Officer John O'Keefe when he said drive by Bella's house? That was Jen talking to John on the phone. Karen's car is going to automatically, it doesn't matter if it's you or your boyfriend, if your boyfriend drove your car, if your boyfriend's phone was connected, it's going to auto connect to the owner, okay? To the primary phone in a Lexus. Why I had one. Not a 2021, babe, but I did have one. 2017, it was blue. And that it didn't matter if me and Mr. Nurse Kim were in the car, my Bluetooth would always connect to my phone. So Karen's phone was connected to the Bluetooth, and John is getting directions with like his, with a handheld device. So it didn't come through the speaker that she was bullshit about that. She heard about who? Bella's mom the next morning when they were on their way back to 34 Fairview, in my opinion.
So the discord in the relationship, the anger, being pissed, the motive, without reading them because it's unnecessary, there is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
Describe the record very quickly. If anything Mr. Brennan just said was true, he might have an argument. My goodness.
Ooh.
It's important to get some of the facts right. You got to get some of them right.
I mean, when I tell you guys, did everybody today collectively lose their minds at one point or another? Mr. Yannetti, bullshit. Okay. We got AJ being like, can everyone, are we on the same planet? Everyone is sick of being in the upside down, can't help themselves. Okay. So then Mr. Alessi, okay, who gets angry, like when Mr. Alessi gets angry and he gets very frustrated, it's principle based, it's integrity based that he was getting like frustrated. And I thought to myself, I swear to goodness gracious, Loveroni with cheese sent me a text, and it was a tweet that said, if Liza Little flips her shit, everyone go to church, right? Like I was waiting for it, just waiting, like teetering on the verge of, oh my God, oh snap, we were right there.
The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the transcript. Every time he stands up, he says, I read the I wasn't there, I read the transcript. We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jim McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry.
I'm sorry. I was talking to my phone. I'm not quite. This was during the time after 5, as they're looking for them. As they're looking for him and searching for him, that's the point at which they have the conversation about being about some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him?
Pissed.
It was in context of when. When were you upset with him? When he didn't come back out. When he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home, before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours of that feeling. Did you feed the kids donuts? Yeah,
Babes, can everybody tell me how much you can relate to, like, did you feed the kids donuts? I have never been a step parent or a bonus parent. And if you have, I'm so jealous of you because, like, Wicked Great, I know that it's incredible. I love my daughters, but I'm bad cop, right? Like, Karen got to come in and be good cop. Okay. This fighting about fucking donuts is the most relatable shit I have heard, like, in my life. I wake up in the morning and, like, sometimes if the spirit moves me, I could start a fight about anything. You know what I'm saying? I have a talent, babe. Not a fight. It's not a fight. That's farce. But I could nudge something in that direction, right? Like, did I wake up in the morning feeling like P. Diddy? No. But I might say, like, oh, no one could do the dishes last night. And I just passive aggressively, right? Oh, did somebody bring you donuts? Right? Was that John? was John the donut whisperer. And he was really pissed about, like, I'm overwhelmed, I'm overworked, whatever it was, and that he always had to be the bad guy. And he was taking it out on the donuts, right? It wasn't about the donuts, but they didn't have problems. So you had to pick the smallest shit, the only shit that you could, to get your little passive aggressive in. You wanted to fuck around. You needed a little combatants. If somebody doesn't fight back with you, then they don't love you. That might be trauma and Irish and Italian parents, but I'm just saying that's how a certain generation was raised.
She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is that night together, lovey-dovey, getting all fine. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Before accusing somebody of getting it wrong, the person accusing should be right.
I don't like his passive aggressive. I don't like it. I don't anything. Okay. I could do without it, Hank. So shut up. Another point I wanted to make, guys, is that we remember, and it was in the ID Discovery, right? The 5-part series, which I have so many thoughts on that. So I've got to get through this. But Karen and John dated. They met in 2004. They dated, and she ended up moving where? Ireland. Shut up. How cool is that? Yeah, awesome. And so they dated for like a couple months, and then she goes to Ireland. You know what she didn't do? Try to vehicularly homicide Officer John O'Keefe. What never has made sense to me at all is that typically there is, and I know you don't have to prove motive, but if we really look at this, Karen had her own home. Karen had her own career. Officer John O'Keefe had his own home. He had his own career. Officer John O'Keefe had his kids. If they wanted to break up, Karen had options. Karen still has options. Officer John O'Keefe had options. He would still today have options. There was no like overwhelming debt. There was no insurance policy. Why would one night? Why? It doesn't make sense. There was no precipitating factors, and Karen doesn't have a history of violence. If you met a couple girls down in Southie, I mean, I don't mean that even in Waltham. You could have a couple girls from Waltham, okay, that I'd be like, that bitch would kill you. She would kill you. Karen's not one of them. Karen's freaking at Bentley teaching on the weekend, like on Thursday nights. And you're like, oh yeah, she was so shit-faced, and he just the thought of anyone else. She said, no one will have you. Ew. Ew. Lifetime wouldn't even produce that, you fucks.
I know that Attorney Jackson was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts.
Yeah, you don't either. Oh, you didn't listen to the interviews or read the transcripts. Shut up. Okay, sorry. I just want to go over here, babes. This was a biggie.
This is in a little bit different posture now than when the Commonwealth filed it back on March 10th, right? With Michael Proctor being fired. Do you need to?
Hearing that come out of Judge Cannoni's mouth, it needs to be framed differently now because Michael Proctor being fired. This was the moment for me, babes. This was the moment for me. This was Big Papi 04. We're winning. We're winning. We're winning the actual, I don't even know what. It was like a series against the Yankees, okay? This isn't our like masterpiece, but it is the start. This is sweeping the Yankees. And I was like, okay, the pieces of the puzzle or the tall blue wall is crumbling. And one by one, the corruption that has occurred in the Commonwealth of Massachusetts and in Norfolk County specifically is being exposed. What is done in the dark will always come to light, babes. And I'm telling you right the fuck now, keep your faith, keep your eye on the ball, and keep fighting for truth and justice like we do every single day. We can do this. All right?
Some time to reconfigure this, or you want to just be heard? I'll give you.
Oh, that was weird. That was weird when she started doing the you can have 2 minutes. I'll give you 2 minutes for that. It felt very pre-K3. It felt very like that's not how it's supposed to be, because every attorney and and the defendant should always be able to present whatever they want in oral argument for the record. And for her to put those time constraints was very concerning to me. And it's making me think, is Judge Bev Canoni about to break? Is she on the friggin' verge of a mentee B? Does she need a grippy sock vacation? Or no, she doesn't. She's just getting more pissed off thinking about less weeks down the Cape.
We'll have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review.
Now, Hank, get a life. You also know this. He says that that both the defense and the prosecution got the IA files on Proctor. Well, babe, if you're fucking gonna try to spin that it may be voluminous, it's something I'd like to review. Oh, Hank Francis, you're gonna tell me that Trooper Michael Proctor, who had 3 full day hearings at the Mass State Police Trial Board, 3 full days of testimony of God only knows what was said. Hopefully we'll find out some of it. Which resulted in a 12-year veteran with like our sort of, what are they, unions, right? Mass State Police is unionized. For him to be fired, guys, dishonorably discharged, he'll never get a pension because you need 20 years. My dad did 25. But he was just a police officer in a city. He wasn't Mass State Police, but you need 20 no matter what. But are you kidding me? That's assault. Shut up. And this is the ace in the hole. Because if you're going to try to skirt around not having Scorty Bello come in for a medical examiner, or you want to dance around her because Officer John O'Keefe's death wasn't even determined a homicide, and the trooper, the lead investigator, has been terminated for his action as it relates to this case specifically. Where am I going to see you, girls? Where am I going to see you? June 3rd, we're going to St. Thomas.
I'm expecting that there may be many pieces of material in that production that is going to be relevant to the defense in this case. And if I have a chance to review it, much object to traditionally findings or opinions of a some constant argument.
Okay, thank you, good sir. And now let's get to Mr. Yannetti. This is my last point, babes.
Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you a 2-minute. When I cut you off after 2 minutes on third-party culprit, and then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're-
last time I said I wasn't excluding it, you just couldn't open on it, right? So that's where I'm at this point, and I'll hear a different side. So
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but
Oh, shut up. Okay, right here he is.
be the 3 that you say it is.
When I tell you guys, I am team Mr. Yannetti. Like I am his very non-consensual intern. And there
All right,
are
so, Ms.
moments
Giannetti, I will
in your
hear from
life
you, and
you will never be the same.
focus
this
on?
may be
Could
one
you
of
tell
them
me
for me.
whether
Was this
this
a
is your
core
third-party
a
culprit,
core
third
moment
party
for
as it
me?
goes to Bowden, or is
Was
this
this my
somebody else did
awakening?
it and
I
you
don't
know
know.
who?
I think it's the second alternative. In other words,
Okay, so that's a little bit different, not pure party. I'll also go ahead. It's a little bit different if it's third party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can
well,
you
it's
make an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
Oh.
Three, yes.
Okay, so can you tell me the three that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert.
Oh, he said it. Oh, he said it with his full chest. Stop it.
I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Oh, I have a lengthy argument prepared with the evidence against each of them. Well, I'm going to tell you this, babes. I'm going to tell you this. Clutch your pearls, get a fucking rosary ready because I trust David Yannetti. Okay? Those dimples don't lie to me. Never have, never will. He's talking this, he's saying this in real time. I'm losing my shit. I go, oh, he said it. He means it. He says it. He means it. Then what happened?
Well, I'm just sensitive to the fact that the court is seeking
Talk to the hand because the face don't want to listen. You know what he is? All that in a bag of chips.
not to,
Oh.
pollute the
So
potential.
we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over?
Guys, take it in. The only fan. Were you hot? I tried to cool off looking at this little bitch afterwards. I go, oh my gosh. He's everything. He is the man, the myth, the legend. A tall drink of water with a skinny tie. Oh, can't tell me shit when Mr. Yannetti is arguing. Thank you, OnlyFan, for cooling all the ladies in the chat off. Woo! Okay. And then we found out afterwards, yeah, because they couldn't talk about this because why? Judge Cannoni, Polly Pocket. And then we find out, oh, yep, they're going to talk about the communication. They'll get that in the 3 days. Alan Jackson is an angel. He is our bearded dragon, not a naked cottage dragon. And then we find out that we will be having court on Tuesday, the 25th at 11 a.m. That is it. Okay, that is my presentation for the
I
evening.
looked through the state and federal
Thank you,
court that
thank you,
allow
ladies
expert-
and gentlemen, for joining me. And now we're gonna talk some shit. All right, babes. Oh, I can take Hank down. All right, ooh. Where are you? Stop sharing. Okay. All right, babes. So now we've gotten through that. Tell me everything. Tell me exactly what you are thinking. What did you think about Proctor's firing? Did you think it was going to happen? Or did you think not a chance in hell the board and the Mass State Police would rally around him? I'm really interested to know because I didn't think it would happen. And I know, and listen, I thought by like in my heart, right? I said, of course it should happen, but I didn't think it would. And it's not restoring like all my faith in Mass State Police, but it is making me feel a little bit more comfortable with Jeffrey Noble, who is a little bit too Third Reich adjacent for me. Okay. His look alone is frightening. It's giving 1930s Germany. You know what I'm saying? And I thought to myself when he got hired, I said, oh, yeah, great. Another one. He was the DJ Khaled of Mass State Police. I go, oh, great, and but he ended up doing the right thing. So I'm impressed because the board and the trial board said, hey, this is our recommendation. The recommendation was the termination, dishonorable termination. But he had to, as the colonel, agree and implement. He did it. So we'll give 2 snaps for Colonel Noble. Now, if you could, help and let us know what happened to Enrique Delgado Garcia, we'd appreciate it. And then, babes, he needs, Jess NB says he needs to be a lot more noble. And MGA Boston, MJA, see, I can't speak either. I thought they would wait till after the trial. Yes, babe. And, oh God, Jiffin Kingdom said, I was just shocked he was fired. I thought he would get a promotion. That would be very on brand, right? They would be like, we're going to remove you from the Norfolk DA's office, okay? And we're going to make you the mayor, okay? You are now the mayor of the fuckery club. And John Courtney said, I wonder if it was part of the federal agreement. Oh, John Courtney, the federal agreement. Okay. I don't know about that. And Antonio, I love Nurse Kim. I love you, Antonio. And Bev wants everything. Yes, she does, babe. You're right. So that I was just that was kind of another push or another, like, I don't know, feather in our hats, right? Or some wind in our sails, because it's been like one knock down after another, after another. We're just dealing with like shoveling shit against the tide all the time. And so that made me feel just a glimmer of hope in the reform of Mass State Police. Now, babes, who of you has watched the ID channel, the 5-part series? Can you tell me, oh my gosh, I'm going to be JFK and James right now. Oh Lord, boys, I'm channeling you. Give me, because I can't ask all of you, but can you give me one word that you thought of it as a whole of the ID series? Because I would say, if I was to pick one word about it, I would say that it was interesting. You did watch it. Yes. Oh, Jeno says meh. Oh. Leanne Doolin said bad idea. Oh. Disingenuous. Carrie B, that's interesting you say that, because Karen had said on Will's stream when she was there, I don't know if you guys all saw that. I'm sure you did, but Karen Reed made her YouTube debut with one of our best friends from out of town, Will the Glarer. And she said that she wasn't expecting much because like there were students that she had and none of them were featured. Nick Rocco was in for one sentence. Don't cry for me, Nikki haircuts. Oh, fly in ointment. Oh. There it is. Island Girl. I did too. I expected it to be much worse. Like, of course, did they put a couple of sound bites that you were like, ooh, that's not the best? Karen, I think there was one point where her and I guess she was just doing an interview, but she said, "Oh, would like to get home and get something to eat." And instead of like cutting it there, she had said at the very end, and a drink, right? But I'm like, what are you trying to do? Why are you trying to make it like that there is alcoholism or something that is nefarious with somebody saying, I'm exhausted, I'm overwhelmed, I'm fighting for my life, and I'd like a fucking piece of steak and a drink? Oh. Yes, Diane Hill, John's ex-girlfriend, was on a bunch. She has been everywhere. I see her everywhere. I see her at court. I see her on every documentary. I see her hiding in a man's closet. I don't know, but she seems to be many places. Oh my gosh. Miss Jess MB says, how long will it take for OJO's ex to move on? Stop it. Oh my gosh. It is wild. It is wild. It's like she was like 25 years ago. I dated Johnny for 6 months. It was the best 6 months of my life. My husband Tim hates him. Still jealous of him. I'm like, what the fuck are you talking about, lady? Oh my gosh. And this is guys, I know I'm sorry, I'm losing it. I'm getting lost in the sauce right now. But I did want to ask you, like, now, okay, now this is just an observation. I haven't seen Erin O'Keefe in court. And like, do you think that maybe Erin, I mean, and I don't wish anything. I always wish the family stayed together, and I don't want bad things to happen to anyone or for a family to break up. You have children. I don't want that ever. But it's very odd because she was at everything all the time. And now I haven't seen her. And it's like a notable loss to me now that when I'm looking at that side and now I'm seeing in the front row is, the girlfriend, the 25-year ago girlfriend. Then it's Paul. And then on the other side is Mrs. O'Keefe. Oh, Allie Brewer thinks that Erin is done with Paul, the Glaze. Yeah. KCL says, I kind of feel bad for what Paul did to Erin. I definitely feel bad. Erin's not a bad person. Paul didn't hurt his brother. Like, stress, trauma, loss, that the O'Keefe family has suffered more than most. And Mr. Betterow always said to us that, like, I know that it's easier to say, like, why don't you see this the way I do? Or like, can't you see that the Commonwealth is fucking with you and fucking with your family? But Mr. Betterow would say, I always give a victim's family a wide berth, right? Meaning, like, let them feel what they have to feel. And, just be there. I feel like it's most appropriate for us, babes, and you do whatever you want to do. But I feel it's most appropriate that, like, if there was a day that maybe they said they looked at something or just maybe realized that they would be welcomed and say, if you wanted to support, that we would be there and think that that was absolutely fine. You could absolutely be welcomed and supported and, kind of wrapped up and told, I'm so sorry. And I'm sorry for everything you guys have had to go through. But I'm not trying to villainize anyone. I just thought that it was kind of shocking that we haven't seen her. And then I wondered, will she testify? Oh, Lally's hair left him. Thomas T. His hair is leaving him. Poor Lally. He's so, oh my gosh, I have the funniest clip. Guys, this was, Thomas T., I love you. We're going to end on a funny note. Ready? This is what I caught, and it made me laugh out loud. Laugh out loud during the hearing today. On your mark, get set. Adam Lally, take the stage.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay.
Lally's little sausage fingers just tippity tapping, right? He's thinking long and hard about his life. He's saying to himself, milk was a bad choice. He's Ron Burgundy, right? And he doesn't even know. And he's just tippity tapping. He's looking at Brennan. He's like, I can't stand you. He looks to the other side, and he's got bitch face McGee, Law McGlaw on the other side, and he's just unwell. Let's look at those little sausages again. One more time for good luck. Take us away, Adam Lally.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay.
I'm sorry. I'm so sorry, guys. Oh, lordy, lordy. And then, let's see. Yeah. And he goes, Kay, right? Judge Cadoni, we've already covered that. Kay. Oh, you got to find the joy in some things, babes, because if we don't, like, we'll lose it. That's why go watch Valhalla and some baby goats. That did bring me joy earlier today. And oh, yep. We're losing it. We're all losing it at this point. Oh, and Miss Jess MB says, I want McLaughlin to return my cheer girls bows to them. Oh, I do. Oh, I have. Oh my gosh. Oh, Mary Malaki, first of my name. My mother, Mary Malaki, is telling me to look at a super chat. How about I shall? Carla, Ohio. Carla, Ohio. Thank you for becoming a Consensual Nurse Kim YouTube member. And for Bettero's affidavit, thank you so much for the super chat, Lovey. I love sharing our feelings with each other. This trial stirs all the emotions. That is what I am here for. Okay. That is what we are here for. If we can't, walk through this with each other, babes, we would be very lonesome, or we would feel like we were losing it, because the gaslighting is on 100 at all times from the Commonwealth, in my opinion. Darlene Wolf says, super sticker. Thank you, Darlene Wolf. And Stacy1201 says, Nurse Kim, we were all assaulted by Brennan today. I'm afeared by this disgraceful POS. Stacy1201, babe, I feel you. I hear you. I am you. Thank you very much for being here. Oh, Ask Bob. Ask Bob, my lovey. Thank you so much for the super chat. To the smartest, funniest, and the most beautiful woman on YouTube. I'm sorry. I'm sorry, Ask Bob. You're not in Melanie Little's chat right now. I'm Kim. Okay. Did you forget? And it's not actually pretty. It is a webcam. Surf. Okay. Surf on. But I love you and I appreciate you. And my orphan methodology said authority. Isn't that the US Constitution? I've got to get better at this, guys. I am so sorry, because I do these at the end and then you're like, what, Kim, don't read that now. But I thank you so much. I have no idea what we're talking about with the US Constitution, but I am a fan of it. I'm a constitutionalist. And Court says, Kim, you're back. Hank needs to go back to his hole until next winter. He already showed us his shadow. It's spring now. Groundhogs are the only other thing so full of shit. That is true. That is true, my friend. I also wonder, though, the constipation is real with him. He is absolutely constipated. He needs to take Miralax twice a day. All right. What also does he do? He doesn't mix it in water. He mixes it in a juice, and he's had side effects. That's what I heard. Okay. After this trial, he is going to have to take another pill for maybe a hyperlipidemia. All right. Or he might need a sleep aid, because he looks a little tired. Since the beginning, since September, I seem to think that both Adam Lally's hair has been, exiting the building. But I think maybe Hank's is getting a little bit thinner in the crown as well. So Hank, I want you to think about that. Okay. Every time you tell a lie, more hair falls out on the pillow. It's an old wives' tale. Okay. And also, if you shake it more than 3 times, you're playing with it. My petty paralegal, my sister, said, you made us so proud on the interview. Love your face. Stop it, petty paralegal. Stop. Did you see it? Oh, don't look. I can't watch it. I probably sounded dumb, but I didn't mean to. And I sat on my hands and I just tried. I was just like, please smile. Please smile. And Vinnie Politan does make me smile. And I think he knows what's up. You know, he's got his corporate job, but he knows what's up. He likes to throw F-bombs. I know he does. He's just professional. I love you and I appreciate you. And oh my gosh, Mrs. Parks in the house. Where you been, lovey? My Mrs. Parks. I'm sorry I'm late, but I'm happy to see all the loveys in the chat. Was so happy to see the Reed team come out swinging today. They were phenomenal. What a day, babes. Babes. Babe, I've had like a 72-hour run that I don't know if I'm ready to crash and like possibly like am I burning out right now? Did I fly too close to the sun? I have felt the highest of highs and lowest of lows. I don't know. I don't know if I'm like, am I exhausted? Am I overtired? Am I happy? You know, I have a giddiness inside me. And then I look at and then what else brings me joy? Little sausage fingers from Adam Lally. Who'd have thought? Oh, and Jeno, I love you. And Couch Potato says, no, do not private tutor that mob lawyer, please. We've only just begun. Your big sister, Shelley. Couch Potato, I shall not, okay? I will not teach him, but I will share our wisdom only for us, okay? We harness the power of good, not evil. We are Captain Planet. And he's a villain. We know this. Thank you so much for being here. Oh, and thank you so much also for becoming a consensual member, my love. And Orphan Methodology said, still laughing over your Polly Pocket position. Well, Judge Canoni is that. She is that bee. You know what I'm saying? She is that little Polly Pocket princess, right? She's been breaking hearts in Norfolk County since 82. She was the biggest. Did everyone see online that Turtle Boy posted that she got like the biggest flirt when she was in high school? Where? Who were you flirting with, Beverly? Who? Did you go steady with a boy? Because this had to be in what, like 19, I don't even know what, 60 something or 7. No, not 60. That's probably she's not that old. 80, right? 1980. And she was going steady with a guy named Chip. And that's why she has affinity for Trooper Proctor. Oh my God. And speaking of Trooper Proctor, why did I have this background tonight, babes? Because this was our final goodbye. This is our last stream that we have to do what? In theory. Let's do it together. On your mark, get set. 1, 2, 3. Punch a Proctor. Because he got knocked out. We KO'd him. All right. One nurse, Kim, smashed the dome this many times over the World Wide Web and graphic imaging. He couldn't handle it. He went down. Okay. Celebrity death matched his ass. He didn't know what was coming. And Mag in Florida says, Kim, Andrea Burkhart has letter on Proctor. Ooh, I will watch. Is she on right now? A letter on Proctor. I'll have to go watch it. I love her. I wish she would come and hang out with us. What a strong and powerful woman. I am such a fan of hers too. To all the smart and pretty women that live upon this land and that are, either talking to us on the World Wide Web, who are boots on the ground, who are just kicking ass and taking names on a daily basis, like, I am in awe of you. And Armor of Alessi said, I'm so proud to be your fan. What? You're not my fan, babe. You're my best friend from out of town, but you shined on CTV. Oh, I love that. Thank you so much. Thank you. Oh, that's I'm going to throw up. Ms. Holmes, 66, said, Kim, this prosecution seriously makes me so angry, and my hubby thinks I'm too invested. I can't help it. I hate Brennan. He's evil incarnate. So yeah, babe, this prosecution, hi, you're home. Hi, Ms. Holmes, you're home, honey. Okay, this is where you belong. We are your people. We are your tribe. Okay, you are not crazy. All of, Mr. Nurse Kim says to me all the time, he's like, you good? I'm like, I'm good. I'm going to go cry in a bathroom. If things happen. But the prosecution is enraging. Mass State Police was enraging. to see how Norfolk Superior Court is behaving. It's enraging us. And once we had the red pill effect, right? And we woke the fuck up, guys, we can't go back to bed anymore. So you're doing what you need to do. You are decompressing and you're on the steam stream with me. And we're letting that steam out, babe. We are your people. And I love you. And that's it. And it is what time? It's 12:05. It's tomorrow. We stayed up till tomorrow together. We stayed up till midnight. I can't even. I feel like if we were with Jimmy right now, he would tell us we could watch the Spice Girls movie together. And we could say, are you going to bed? No, are you going to bed? Okay. Well, I am going to bed because 5:30 is going to come very quick. But I am so happy that I got to see all of your faces and I love you so much. And I'm going to, oh, babes, oh, dumb I am. I'm going to do the 12 for 12, the expert stream on Sunday morning. Let's do a Sunday service. I'm going to read all of the Karen Reed Defense Fund donations. We're going to talk all the shit. We're going to have guests. Do I know who? No, I don't. But I'm going to throw out a thing to the boys. And I'm going to say, hey, show up and help your girl out. Because I show up for them. And I know they will. So if you wanted to donate for Karen at this time, because we know that we are still shoveling shit against the tide. I know that she would appreciate it. I know that the Reeds appreciate it and that they read every single one of those, babe. You guys make the difference. I don't make the difference. You do. Okay. And one more punch of Proctor for good luck because that motherfucker was Chips Ahoy. Okay. He's going to be chocolate chip in the pen, is what they say. On your mark, get set, punch of Proctor. Bye, loveys.